Hello, my name is Mark Skuse. I am Senior Legal Counsel in the OSC's Compliance and Registrant Regulation Branch. It is my pleasure to introduce you to today's Registrant Outreach session called Registrant Applications and Filings and the OSC's Whistleblower Program. Before we begin, please bear in mind our standard disclaimer slide. We have 4 topics to cover today. The first will be CSA Staff Notice 33320, the requirement for true and complete applications for registration. The presenter for this topic is yours truly. Second, we will hear from Camaria Hu, a registration supervisor in the Compliance and Registrant Regulation Branch, about outside business activities and Form 33109F5, change of registration information. After that, our topic will be common issues in reports of exempt distributions, which will be presented by Kian Sleggs, a business analyst in the Compliance and Registrant Regulation Branch. Finally, we will hear from Ashok Menon, Investigation Counsel in the Enforcement Branch, about the OSC's Whistleblower Program. As per our normal practice in registrant outreach sessions, we will respond to questions at the end of the presentation. However, if you do have questions, we encourage you to submit them during the webinar. Our first topic is CSA Staff Notice 33320, the requirement for true and complete applications for registration. My work at the OSC is generally focused on investigating misconduct by registrants and applicants for registration, and so I am speaking to you today about the issue of non-disclosure of registration information. Here is an overview of my presentation. You'll note that I've indicated that the presentation is based on, but not limited to, the staff notice. My plan is to use the staff notice as a platform to discuss some things that aren't necessarily addressed in the document, but are nevertheless related to the issue of non-disclosure of registration information. I hope that you will find this to be of some added value. So in this slide, I've tried to address what the big fuss about applications not being true or incomplete. And to put the discussion in context, I'm not talking about a missing postal code or an incorrect date, although under some unique set of facts, that could be material. Instead, I'm talking about things that are on their face material. An omitted criminal conviction, an undisclosed bankruptcy, a greatly exaggerated description of one's past employment duties, or a self-serving explanation about why they were terminated from their last job. For an individual to be suitable for registration, they must satisfy the 3 criteria of integrity, proficiency, and solvency. Information disclosed on an application for registration informs OSC staff's assessment of whether they are suitable for registration. But if an individual withholds required information, then that too can be probative of their suitability for registration, and in particular, it can be probative of their integrity. The concept for the CSA staff notice was proposed by the Registrant Conduct Team here at the OSC, also known as Team 4, of which I am a member. In fact, it was proposed by me, but the proposal was sparked not just by my own experience, but by the experience of my colleagues on Team 4. It is Team 4 that handles many of the non-disclosure review cases here at the OSC, and so I have included this slide to tell you a bit about us. We were established in 2010, which coincides with the introduction of the director's power to suspend registration. Team 4 is staffed primarily by lawyers with litigation experience. There are 4 lawyers on the team at present. There is also an accountant and 2 other long-time employees of the OSC with a wealth of registration-related knowledge and experience. Our primary job on Team 4 is to investigate allegations of misconduct by applicants and registrants, which often include issues related to integrity, to make recommendations for regulatory action to the director where appropriate, and if necessary, to represent OSC staff in administrative proceedings where our recommendation is challenged by an applicant or a registrant. Untrue or incomplete applications for registration are a long-standing problem at the OSC. The OSC Bulletin, which no doubt you'll have all read cover to cover, began publication in January 1949, and the first case reported in the Bulletin was about a man who did not disclose on his application for a securities license that he had been denied one in Quebec. Time marches on, and 70 years later, the OSC is reviewing approximately 7,600 applications for registration every year and overseeing approximately 68,000 registered individuals. About 80% of the registration activity in our branch relates to mutual fund dealing representatives, and this is because the OSC has the registration authority for this category of registration. The population of applicants and registrants, like the population at large, is generally law-abiding and follows the rules. However, given the huge number of applicants and registrants in this province, if even a small percentage of them fall offside the disclosure rules, it results in a large absolute number of cases for us to look at. It is also worth noting that only a tiny fraction of the cases end up in a published decision that you see on the internet or in the OSC Bulletin. Many applications that suffer from misleading information get withdrawn by the firm before a final decision is ever made by the director. But there is still a considerable amount of work that has to be done on our end leading up to that point, as we want to be careful that we have all the facts in hand before we allege that someone has acted dishonestly. So much of the work that goes on in this area you will never see reported. Given the volume of these types of cases and the draw on resources they impose, in late 2016 we broached the idea of a CSA staff notice on this topic with our colleagues in other jurisdictions. And after several months of consultation and drafting, the notice was published in July 2017. The majority of the cases referred to in the staff notice are from Ontario, but disclosure is by no means an Ontario-only issue, and the document does draw on cases from other jurisdictions as well. We're under no illusion that the publication of the staff notice is going to eradicate the problem of false or misleading registration applications. For so long as humans are submitting these applications, these kind of cases are going to come up. But it is our hope that the staff notice will dissuade at least some people from engaging in this type of deceptive behavior. And to the extent there are any genuine misunderstandings as to what is expected by the questions in the application form, the staff notice contains some guidance on that as well. So that's the background to the notice. Now I'll get into the substance of the notice itself. I've touched on what we hope to achieve by the staff notice, which is to reduce the incidence of untrue or incomplete registration applications. On this slide, I've set out the 4 things we tried to achieve within the notice itself. Those are to alert stakeholders to the issue, to summarize the statutory obligations, to address some common reasons given for non-disclosure, and to provide guidance for completing applications. The fundamental issue at play here is that non-disclosure can impugn an applicant's integrity for registration or a registrant's suitability for ongoing registration. The issue is described in a 1972 decision of the OSC called Re Thomas, which involved an individual who did not disclose a criminal charge on his registration application. The OSC described that issue in a quote that is one of my favorite in all of the OSC jurisprudence because of its eloquence, brevity, and accuracy. And that quote has been reproduced in the staff notice. The key to the registration system is the application form. A desire and an ability to answer the questions in it with candor in many respects can be said to be the first test to which an applicant is put. The statutory obligations in this area are very few and very simple and are found in National Instrument 33-109. Section 2.2 says that an applicant must submit a completed Form 33-109F4. Section 4.1 says that a registrant must update information previously submitted in their F4 within 10 days, except for 2 enumerated items of information, which have 30-day update timelines. And subsection 5 sub 1 says that a sponsor firm must make reasonable efforts to ensure the truth and completeness of information submitted by its individuals. It should be noted that most jurisdictions have a provision in their act that make it an offense to submit misleading or untrue applications. In Ontario, this provision is found in Clause 122B of the Act. However, even if an untrue application is not prosecuted in the courts under this provision, it can still impugn the applicant's integrity for registration. The Form F4, the application form, is the main document we're concerned with in this discussion. The form has 22 items, some with related schedules, and the last 4 items are notices, certifications, or acknowledgments. Item 21 in particular is worth noting. It says, it is an offense under securities legislation and derivatives legislation, including commodity futures legislation, to give false or misleading information on this form. So that repeats the offense provision in Section 122 of the Ontario Act. So if an applicant doesn't include information, or if they misrepresent information on their F4, how does OSC staff detect this? There are various ways in which this can come about, and I've identified the key ones on this particular slide. For example, when we receive an application for registration, we will run a police record check. Likewise, applicants' names are run through a bankruptcy record search, which has resulted in us identifying many applications where item 16 has not been completed properly. Detecting non-disclosure really isn't the hard part. The hard part comes next when we try to assess what that means for the applicant. It's at this stage in the process that OSC staff has to try to determine whether the applicant is culpable for the non-disclosure, which often means trying to figure out if they're lying to us, or whether there is some innocent explanation. We usually do this through an interview process, and this is where the expertise of Team 4 is really brought to bear. I've done a rough tally, and I estimate that in my 8 years here at the OSC, I've personally conducted approximately 100 interviews with applicants and registrants. Many of these interviews are related to issues of disclosure, and most involve, as a significant component, the requirement to assess whether someone is being truthful about the topic being discussed. In these interviews, we generally explore two issues. Did the individual disclose the matter not disclosed on NRD to his or her sponsor firm, including when, to whom, and how? And if they did not, then why not? When OSC staff conducts these interviews and considers the explanations offered for non-disclosure, we generally apply the guiding principles that I've set out on this slide 17. It does happen from time to time that someone will admit they intentionally omitted something or misrepresented something on their application form. But for the most part, that is very rare. More commonly, someone may say that they did not read the question either carefully or in some cases at all. In such circumstances, perhaps they were not intentionally being dishonest, but such a lack of diligence is not acceptable and is captured by the expanded definition of integrity that we see in the John Doe case from 2010. Another common occurrence is that someone may adopt a self-serving interpretation of the questions in the Form F4, such as by reading in exceptions and limitations to the disclosure obligation that just aren't there. This is not acceptable either, and is addressed in the 2012 Couteau case. In slide 18, I've identified possible outcomes from a review of a non-disclosure situation. In the case of a refusal or a suspension, OSC staff can only make a recommendation. The decision to refuse or suspend ultimately rests with the director, and the applicant or registrant is entitled to an opportunity to be heard by the director before any such decision is made. Not infrequently, a sponsor firm will make the decision to withdraw an application once it becomes aware of a disclosure problem. In this case, the application goes away because of a decision of the sponsor firm, and therefore there is no opportunity to be heard with the OSC for the applicant. A non-disclosure case isn't a welcome event for anyone. For OSC staff, it represents a draw on our resources. For the firm, they're likely going to have to respond to requests for documents by OSC staff, sometimes a lot of documents. For the individual, they will likely be required to attend an interview with us to review the issues. Sometimes those issues are sensitive, like criminal charges, bankruptcies, and terminations for cause. So that isn't an experience that most applicants or registrants enjoy. In my last slide, I've identified some steps that firms may wish to consider in an effort to prevent these types of cases from arising in the first place. For some of you, these may be steps that you are already taking. For others, this will be new. In each case, you'll have to assess for yourselves what works in the context of your particular firm, bearing in mind the requirement to take reasonable steps to ensure the accuracy of the information your applicants are submitting. It's unlikely that any system is going to be 100% reliable. If someone is dead set on lying on their application, then they're going to lie on their application. However, here are some steps that you may wish to consider implementing. First, require the applicant to complete the application in full. This sounds simple enough, but I have encountered situations where a firm asks their new hire, who has come from another registered firm, whether anything has changed on the NRD. That's it. And then they proceed to submit the application for the individual. Unfortunately, in that case, information had changed, and the individual simply didn't turn their mind to it, possibly because of the manner in which the question was put to them by the new firm. This isn't a particularly helpful process. Put the question in front of the applicant, either online or in paper, and have them read and respond to each individual question themselves. Second, review the completed application before it's submitted. Carefully examine the narrative sections, such as the description of past experience and reasons for termination. Firms should be looking these applications over before they're submitted. If someone says in their application that at their last job they designed investment portfolios for clients, but they've never been registered, then that's a red flag that should warrant examination by the firm, and you can think of many other such examples. Police criminal record checks and police information checks are also a good idea. These types of background check services can be obtained from private service providers. A word of caution, though: understand what it is you're paying for. For example, there is a difference between a police criminal record check, which should only uncover non-pardoned convictions, and police intelligence checks, which will capture a wider range of information, such as pending charges and absolute or conditional discharges. The questions in item 14, which is the criminal disclosure item, will not be satisfied by a police criminal record check alone. Bankruptcy searches. These can be performed through the Industry Canada website and do not cost a lot. Obtain the applicant's notice of termination. Review the contents carefully and ensure the details they provide on their application about why they left the job are consistent with what is contained in the notice of termination. Ensure that individual codes of conduct address the requirement to update registration information on an ongoing and timely basis. Annual compliance attestations are a good idea. They should clearly identify each item on the F4 and should include a clear statement from the registrant that their F4 is up to date, and should inform registrants about the serious consequences that can result from non-disclosure, including a loss of their registration. Once notified, prioritize reporting and investigate after. There's probably a strong desire to get to the bottom of an issue once a registrant informs the firm about a reportable event such as a criminal charge. It's understandable, but and such inquiries are appropriate, but the priority really should be reporting the matter on NRD as soon as possible. The Form F4 does not require a comprehensive encyclopedia of information to be disclosed about the event. OSC staff can and will follow up with the firm, the individual, and other third-party sources of information to get a better understanding of what happened once we've received the notice through NRD. Branch managers and colleagues play an important role when it comes to ongoing reporting. Registrants develop a personal relationship with their branch manager and colleagues and may confide the existence of a reportable matter to them, often before reporting it through official compliance channels. Branch managers and colleagues need to encourage the individual to report the matter through the appropriate channels, which may be through the branch manager, depending on the firm. If the individual indicates reluctance to disclose to the firm, then the branch manager or colleague may have to report the matter themselves. And my last item is to remember Watergate. The cover-up is often worse than the crime itself. The recent Milligan case is a prime example. There, the registrant engaged in relatively minor criminal misconduct, but he did not report the matter as required and ended up being suspended for it. Remember that even if the underlying unreported event itself occurred some time ago, so even if it's a conviction that occurred some time ago, the act of failing to disclose it is new conduct, and it's going to be treated as such by OSC staff. Thank you for your time. I hope this session has been informative and helpful to you. I'm now going to turn it over to Camaria for a discussion of outside business activities and the Form 33109 F5.
Thank you, Mark. I'm Camaria Hu, Registration Supervisor in the Compliance and Registrant Regulation Branch at the OSC. My presentation today will cover outside business activities and Form 33109 F5 filings, which I will refer to as the OBAs and F5 respectively throughout this presentation. Today I'll talk about OBA filing expectations and common deficiencies, conflicts of interest and what should be reported, restricted client terms and conditions and examples of positions of influence, and F5 filings, expectations, and best practices. First, let's discuss what a registrant must do in regards to OBAs. They must have policies and procedures in place to identify changes to the F4 information. They must have policies and procedures in place to identify and address conflicts of interest with respect to OBAs, including potential influence and client confusion due to undue influence. They must document any action and analysis the firm takes to determine that an OBA does not require reporting. And the OBAs should be looked at on a case-by-case basis, as each OBA may have different variables that affect the decision. And finally, they must notify the regulator of updates to item 10 of the F4 within 10 days of the change. Some of the common deficiencies that we see when OBAs are being reported are that there's insufficient description of the outside firm business activities and the individual's duties. Titles are not sufficient details. Registration officers need enough details to be able to properly assess whether an activity creates potential conflicts, so that we can determine whether terms and conditions might be required or not. We also see inappropriate or insufficient assessment of actual or potential conflict. And this one is more of a technical issue, but when addressing the conflicts of interest in an OBA, we tend to see sometimes firms address those conflicts of interest in the entry of the sponsoring firm rather than in the entry of the OBA itself. So things to consider when evaluating conflicts of interest might include asking questions such as, will the individual have sufficient time to properly carry out their registrable activities? And that might include remaining current on securities law and product knowledge. Will the individual be able to properly service clients? Is there potential for client confusion? So will the client understand which hat the individual is wearing when they're giving them the advice? Are there effective controls and supervision in place to manage the risks? And does the OBA present a conflict of interest for the individual? And should that conflict of interest be avoided, or can it be properly managed? Other things you might want to consider is asking, does the OBA place the individual in a position of power or undue influence over current or potential clients? Can potential clients be characterized as vulnerable? Does the OBA provide the individual with access to privileged, confidential, or insider information relevant to their registrable activities? And does the individual have privacy privileges in regards to information disclosed by the client? OBAs that should be reported include all employment and business activities with the sponsoring firm and outside of the sponsoring firm, all officer and director or equivalent positions, paid or unpaid, and these may include non-leadership positions, and activities where the individual is in a position of power, influence, or position that places the individual in contact with potentially vulnerable clients regardless of whether the position is voluntary or paid. Some of the OBAs that we commonly see not disclosed, that should be disclosed, include having more than a negligible percentage ownership in a holding company. Whether the company is active or passive, it does need to be disclosed. Being a trustee, being a landlord or an owner of a tenanted building, and doing tax planning services. The OSC proposes restricted client terms and conditions on OBAs that are considered to have influence. The next two slides provide examples of positions of influence, so firms understand which OBAs will require restricted client terms and conditions. This list is not exhaustive, but these are some of the common ones that we see. So it includes pastors or equivalent, a lay pastor, an elder, a president, or other figureheads of the church, teaching at an accredited school and administering grades, coaching a professional or a feeder team to the pros or the semi-pros, mentoring youth through an organization or being a life coach, caring for vulnerable people, or sitting on the committee that makes decisions about vulnerable people. Being a doctor or a nurse, a pharmacist, or a naturopath. Being a lawyer or anyone who works for a law firm, a lawyer or a client to whom attorney-client privileges are extended. Being an immigration official, a consultant, an agent, or any equivalent position to that. And roles handling in the investments of an organization. So now let's move on to the expectations regarding F5s. So a firm is required to notify the principal regulator of a change to any information previously submitted in the F6. And this is done through a completed F5. And there are timelines as to what information needs to be submitted when. The baseline, I would say, is 10 days for most disclosures on the F6, excluding Part 3 of the F6, where the requirement is for a 30-day time period to notify of any changes. There are situations where an F5 is not required, and that would include a business location change other than the head office. And that should be submitted in the form of a completed 33109 F3 on NRD. Another case is when a sponsoring firm, is adding, terminating, or changing an officer, partner, or director. If the firm completes either an F1, an F4, or an F7 on NRD, which they're required to do, then they're not also required to make a submission through an F5. Now, let's talk about best practices for making these F5 filings. The F5 filing needs to reflect changes to the F6, and it should always be accompanied by a black line of the amendment to the form. And the F5 actually states this requirement in item 1, in the type of form. So it's very important to ensure that, a black line is being submitted with that change. In some instances, we see things like in part 3.1, the business model change, where we're just presented with what the new business model is, as opposed to being presented with what is currently being done and what is being proposed. That gives staff a chance to do an evaluation based on all the facts rather than only what is being proposed. Also, 3.12, the ownership change, it's best practice to highlight on the chart who is being added or removed, the percentage change, or whether it triggers an 11.9 or 11.10 notice, and the type of business a newly added affiliate or subsidiary operates. And another example is in Part 7, the regulatory action update. It's best practice to be clear whether the notice is a change in regards to the registrant firm or its affiliates, and submitting documentation along with any notice regarding the registrant firm. So that ends my presentation. I'm going to pass it on to Keon Sleggs, who's going to discuss common issues in reports of exempt distributions.
Hi everyone, my name is Keon Sleggs, and I'm a business analyst at CRR. Over the next few minutes, I'll be going over some common issues that we find in reports of exempt distribution in regards to firms and compensated parties in general. In particular, I'm going to be talking about Item 4 and Item 8 of the Form 45106F1, as well as the compensated person field in Schedule 1 that accompanies the form. We'll begin with Item 4, which contains underwriter information, and that's the top image on the slide there. If an underwriter is completing and certifying a report of exempt distribution, the name and, if applicable, NRD number must be entered here. Similarly, if direct compensation is provided in connection with the distribution, Item 8, which is the bottom image on the slide, must be completed as well. If the compensated party has an NRD number, it should be provided. In order to avoid having to amend your original submission, please ensure that the correct NRD number corresponds to the proper registrant name. And I should remind you that the National Registrant Search is an excellent tool for finding a firm's NRD number. You should also ensure that the registrant name is spelled correctly and in its complete form. Abbreviations and short forms should be avoided. Common errors are often a result of extra or inverted digits in the NRD number fields. Note that adding extra zeros or entering an incorrect NRD number may link different, existing, or future registrant to the filing. And a negative response to the registrant indicator in item 8 is acceptable if the person is exempt from registration or is otherwise not a registrant according to the most current NRD records. Firms relying on the International Dealer Exemption or the International Advisor Exemption, as set out in Section 8.18 and Section 8.26, respectively, of National Instrument 31103, are not registrants and should select No at Item 8A. However, they have been assigned a firm NRD number and should enter it in Item 8. So in addition to Item 8 of the form, the compensated person information must also be correctly completed in Schedule 1. The name of the field reads full legal name or person compensated for distribution to this purchaser, and it is the last column, column Z, in the Schedule 1. The Instructions tab of the Schedule 1 template provides further information on how to fill out this field correctly. So filers should fill out the field as follows. Filers should provide the full legal name of the person compensated. However, if the person compensated is a registered firm, provide the firm NRD number only. When providing the full legal name of an individual, indicate the family name first, followed by first given name and secondary given names. One of the most common issues that we see is that filers are including names of registered firms in the compensated person field of the schedule, either instead of or in addition to the firm's NRD number. So often they'll have the firm name and then in brackets say NRD number 12345. We only need the NRD number. And just to reiterate, only include the NRD number in this field for registered firms. In addition to these instructions in the template, we request that when indicating multiple compensated persons in the same field, the names and/or NRD numbers should be separated by a semicolon. Of course, the names and NRD numbers indicated on the Schedule 1 must be consistent with those provided in Item 8 of the report. We also notice some issues when filers are including the names of individuals or non-registered firms. The most common one is the use of names that are unclear or slightly different than those on the form. When indicating the name of an individual or non-registered firm, please use the complete name, as indicated in Item 8, not short forms or initials. As seen in the examples on this slide, for Example Firm Inc., putting just Example or EFI on the Schedule 1 would be incorrect. Finally, if there is no compensated party, please leave the field blank. There is no need to include NA or any other such indicator. For further information on filing requirements and common issues in reports of exempt distribution, I encourage you to check out the OSC's Exempt Market webpage and to tune in to the OSC's upcoming SME webinar focusing specifically on these topics. This slide includes links to both for your reference. Now I'll hand over things to Ashok, who will be talking about the OSC's Whistleblower program.
Hello everyone, it's a pleasure to be here to speak with you. My name is Ashok Menon. I am legal counsel with the OSC's Office of the Whistleblower, or OWB as we call it. I'm here to talk to you about the OSC's Whistleblower program and some of our compliance efforts dealing with the whistleblower provisions of our Act. That's Section 121.5, which protects against reprisals and renders unenforceable contractual provisions which seek to silence whistleblowers. These provisions are critical to ensuring that whistleblowers feel comfortable coming forward and reporting misconduct. Because of how important these provisions are, we conducted a compliance review, or a desk review as I'll call it, of registered firms to assess how they were faring against the whistleblower provisions of our Act. This presentation is aimed at providing you some background on what we did and what we found. But if you could stand the suspense, we'll first take you through a bit of a background on the program itself. The upshot of all of this is that whistleblowers perform a valuable public service by helping to identify misconduct, which may ultimately reduce investor harm. We think it's important that they therefore be protected against reprisals and silencing. In terms of an agenda, we'll first give you a brief overview of the OSC's Whistleblower program. We'll then talk about our desk review of registered firms, including a breakdown of some of our key findings. So, what is the Whistleblower program? Broad strokes, the Whistleblower program offers financial incentives for information about securities law violations. It also provides what we think are some pretty robust protections for whistleblowers to come forward. The program and the Office of the Whistleblower were launched in July of 2016 to target serious and hard-to-detect violations of Ontario securities law. At around the same time, we amended our Act to include the whistleblower protections that I'll get into shortly. Just to give you a lay of the land, the Office of the Whistleblower is situated in the enforcement branch of the OSC. Enforcement programs are designed to meet three goals: investor protection, accountability, and credible deterrence. The more quickly and effectively we resolve enforcement matters, the better we can achieve these goals. The Whistleblower program is just one of a number of initiatives aimed at resolving matters more quickly and effectively. To mark the program's second anniversary, we recently announced some stats on how we've been doing to date. The program has generated approximately 200 tips, roughly 10% of which have been referred to enforcement investigation teams, some of which have also been shared with other OSC branches or with other regulators. Awards are paid after cases are concluded and all rights to appeal have expired. To date, there have been no public announcements on payments made under the program. So what are we looking for? We're looking for timely, specific, and credible facts which provide meaningful assistance to our investigations into hard-to-detect violations of Ontario securities law. In terms of subject matter to date, we've been receiving information that runs the gamut from disclosure issues to fraud and insider trading. We're very happy with the information that's been submitted to date. So let me take you through a bit of the process and in so doing address some of the program's key features. First, a quick note on eligibility of a whistleblower. In the policy, we have defined a whistleblower as an individual or two or more individuals acting jointly who provide information on a voluntary basis about a violation of Ontario securities law and submits information in the manner described in the policy. Whistleblowers can also report anonymously through counsel if they so choose. The purpose of having counsel serve as an intermediary is to facilitate communication and assistance between the whistleblower and staff, to serve as a point of contact, essentially. Getting back to eligibility, certain people are ineligible with no exceptions. Think about people who, for example, knowingly submit false or misleading information, or indeed staff of the OSC who are also ineligible. Certain people are eligible if they meet a higher threshold of criteria. Think about CCOs, for example, who, because of the nature of these individuals' job functions is to consider and address misconduct internally, we hold them to a higher threshold when it comes to eligibility. I also want to talk about one class of whistleblowers who, it may surprise you to note, is not ineligible, and that's culpable whistleblowers. We conducted an extensive consultation process before rolling out the program. We spoke with civil society organizations, government agencies that have whistleblower programs, whistleblowers, and their counsel. During the course of these consultations, we heard that it takes a rogue to catch a rogue, which is sort of a dramatic way of recognizing that culpable whistleblowers may have maybe a fruitful source of information. With that in mind, we sought to strike a balance, recognizing that hard truth, while addressing concerns that they ought not profit from their misconduct. To that end, among other things, a culpable whistleblower is eligible for a whistleblower award, but receives no immunity from prosecution. Also, the degree of culpability is a factor that may decrease the amount of the award. Once we obtain the information, the OWB triages the tip. If the subsequent investigation results in what we call an award-eligible outcome, which is a proceeding under Section 127 of our Act, the whistleblower may be eligible for a financial award. In terms of financial awards, eligible whistleblowers may receive awards of between 5 to 15% of the total sanctions imposed and or voluntary payments made in cases where sanctions total $1 million or more. The amount of the award is capped at $1.5 million if no sanctions are collected, and capped at $5 million where sanctions are collected. Now, on to protections. As I mentioned at the top, there are a number of protections in place to make whistleblowers feel comfortable in coming forward. One of them is the confidential reporting option for a whistleblower who comes in through counsel. In general, we will use all reasonable efforts to protect the identity of a whistleblower, including information that could reasonably be expected to reveal the whistleblower's identity. We do have some carve-outs, including where disclosure is required by law. We also have the anti-reprisal or whistleblower provisions of the Act, which was the focus of our desk review. These provisions make it a breach of the Act to take a reprisal against a whistleblower and render contractual provisions designed to silence whistleblowing to be unenforceable. A reprisal is broadly defined to include any measure taken that adversely affects their employment. It can include disciplining, demoting, or suspending an employee, or threats to do the same. It's important to note that the anti-retaliation provisions or whistleblower provisions apply to those who report or seek to report internally within their organizations, to the commission, to an SRO, or to a law enforcement agency. We're pretty happy with that breadth. In December 2017, the Act was further amended to provide a statutory civil right of action for whistleblowers who have had reprisals taken against them. This is an important development from our perspective as well. With that in mind, let me go into some of the findings of our desk review. So backing up for a minute, in 2018, we conducted a targeted review of 30 registered firms. We found that a significant portion of firms reviewed had employment agreements that contained inappropriate language. I just want to touch upon some of what we saw and what I mean by inappropriate language. I'd like to talk about 3 buckets in particular. First, language that prohibits any and all disclosure of information without an exception for reporting potential violations of securities law. This could be language to the effect that I, as the employee, agree not to make any complaint to any governmental or regulatory authority. This is effectively a thou shall not report provision. For obvious reasons, we take issue with any provision that would require an employee to represent that he or she will not report to the OSC's whistleblower program. The second bucket is language that requires that an employee notify or obtain consent from an employer prior to reporting information. We take issue with this because if an employee needs to get the consent of their management to report misconduct, how likely are they, in fact, to report that misconduct? This will have the effect of silencing someone who would otherwise come forward. The third bucket is language that allows for disclosure, but only as required by law. Prohibiting a disclosure except as required by law is problematic for us because these whistleblower tips are voluntary. To be clear, whistleblowers are not compelled to come forward. They are doing so, they're not doing so, I should say, out of a legal obligation or duty. Only allowing employees to come forward where they have a legal obligation to do so without any exception for voluntary communications with a regulator or a law enforcement agency would, in our view, have the effect of undermining the program. Finally, some other language that we find equally inappropriate is language that limits the type or types of information that an employee may report, or requires representations that an employee has not assisted in any investigation involving their employer. In coming across this type of language, we've encouraged firms to conduct appropriate remediation efforts in the event agreements contain such language. This could be by way of revision of agreements or distribution of general notices to employees who have signed such restrictive agreements. Finally, I want to touch upon some practical considerations. So part of our mandate is to promote the program, but also to encourage market participants to have their own systems in place to accept whistleblower reports and, very importantly, to deal with them effectively. We always encourage organizations to get their own internal controls in order, because it's obviously much better for them to deal with these issues than to have a regulator knock on their door. One of the things I often talk about to make this point is based on the US SEC's experience in their whistleblower program. They found that 62% of the awards paid were to current or former employees, and about 83% had raised their concerns internally before reporting to the SEC out of inaction. This is it's a bit of a cautionary tale. We hope the program provides entities with the opportunity to look at their internal compliance system and to determine whether a culture of compliance is being fostered. With that, I will point to some useful resources, and we are happy to take any questions you may have on any of the topics discussed.